Welcome to the YouTube channel Mentor Securities M&A Corner Office. This is the second in a series of videos about selling your company. In this session, we will discuss how we would qualify a potential client, a prospect, and we're also going to give you a little bit of background information on that prospect. So picture us being in the room with the prospective client who wants to sell his company. And I'm joined today, I'm Davis Blaine, chairman of Mentor Securities. I'm joined today by partners Eric Klein, Gary Lotzer, and Rhett Plotner. So, gents, let's just jump into this. I want to give some background for the people who are going to hit like and join us on the YouTube channel. This is a client that makes industrial valves. They do 45 million in revenues. They're showing profits of 4 million. They did a quick calculation of EBITDA and came up with 5 million. We did our own calculation to come back to this second meeting, and we came up with an adjusted EBITDA of 7 million. And we've also done some analysis of the multiple. We've looked a little bit at the industry, and now we're going to dig deeper into this prospect to make sure that they want to hire us and that we want to be hired by this company. So let me start with Rhett. Rhett, you did some analysis on the multiple. How did you go about determining that? You accessed obviously some data sources on the internet. How did you go about determining that multiple?
Sure, there's a multiple database sources for current industry models as well as historical industry models as it relates to EBITDA and revenue models. Some industries trade on revenue over EBITDA models, but the majority are going to trade on EBITDA multiples. Typically, there's a range, and that range is determined by numerous variables, especially within different industries. The range can vary considerably amongst different industries and even some businesses. So there's going to be a range, a low and a high. And to typically get a ballpark, we look at the median over the average to sort of strip away any
outliers,
normal, any large or small that might push that average away from the true middle. And from there, we take a look at the respective business that we're looking to value and determine an appropriate EBITDA multiple that can generate the appropriate value.
Right, and buyers and sellers understand that EBITDA or even revenue times a multiple is an easy way to get your arms around enterprise value. In this case, I think we came up with a multiple like 6 to 7 times EBITDA. Gary, you did a little analysis on their EBITDA, which was actually great because you found more things that got that EBITDA pushed up to right around that 7 million as opposed to 5.
Yes, as a matter of fact, starting out with the reported EBITDA of 5 million, we were able to find add backs to actually take the 5 million to approximately 7 million. Some of the more significant categories of those adjustments that we made to the reported EBITDA was owner compensation, owner perks, any retirement benefits are being paid by the company, and so on and so forth. And in the aggregate, we added approximately $2 million to the reported EBITDA. And a multiple of 6, that means we increase the enterprise value by up to $12 million.
Wow, that's great. Yeah, and we usually ask the client or the prospect for their first shot at EBITDA, but we do our own analysis, which is what you did, which is great. Eric, one of the other things that we would be asking the client at this stage is a little bit of background on their industry and where they stand. Are they, which number are they? In this case, I think we found that they were number 3, but how would you go about asking about the industry and maybe about intellectual property and some other things?
Yeah, I mean, a couple of the things that I would start out with is, how unique is their product as compared to their competitors?
Mm-hmm.
What advantages do they have, whether it be product features of the product, pricing, other elements of the product and how it benefits the clients in the marketplace, as far as how they compare to other competitors. Is their customer service better than the competitors?
Mm-hmm.
That sort of thing.
Got it. Well, I think that industry background is really critical because at the end of the day, and most companies that are selling don't want to go to their competitors right away. But at the end of the day, a lot of times, as a last resort, we'll bring in a competitor into the process because often they become the best buyers.
Right.
Yeah.
And then just to kind of dovetail into that is, I agree with you, Davis, that you typically would want to go to your competitor last, because what'll happen is that we will get bids from other strategics and financial buyers.
Yep.
And kind of use them as sort of a stalking horse to compare their pricing to up the price. And typically, those competitors will pay a higher price, especially if they're strategic over financial. So, that's a way to get a higher price for the client.
Exactly. Now, Rhett, another thing that we want to go into at this stage, because this is kind of our diligence with this prospect, would be things like agreements. So what are the types of agreements we might be looking at, like vendor contracts? What else might we be looking at?
Yeah, definitely vendor contracts, leases, any sort of, especially your client contracts.
Okay.
Any sort of legal document that is germane to running your business.
Okay. We also want to find out if those contracts have to remain in place or if we have to get approvals, right? Because on government contracts, they may need approvals as part of the purchase. So
Yeah, absolutely. If there's any sort of vendor approvals may need to be sought.
right.
Yeah, another, Davis, I'd like to jump in there
Sure.
on that point. What's also really important is, typically, I'm going off tangent a little bit, that buyers typically want to do an asset sale and sellers want to do a stock sale. And if
Right.
those contracts are not assignable, there's a 338 election, there's some nuances to ways to do the deal where the contracts can be assignable, but it's a little bit more of a challenge if it's an asset sale. So that's
Right.
something to be mindful of.
Right, exactly. And going back, Gary, to the financials, I know you did a lot of analysis. We would typically ask the client if they would make some cash flow projections, right? And then we also want to find out what state are their financials in? Are they reviewed? Are they audited, et cetera? So,
Yes. We did coordinate with management, principally the 2 owners of the company.
Mm-hmm.
And we obtained their CPA prepared reviewed financials. So we're blessed with reviewed financials, which
Okay.
is a serious quality of, a gap with footnote disclosures and so forth. Only 1 grade below audited financials, which are pretty rare to find these days.
Right, especially with a private company. True.
Absolutely, yes.
Yeah.
And it's a major CPA firm as well. And in addition to that, we coordinated with the company's CFO, And she was able to provide us with some very comprehensive 5-year forecasts. And we worked
Oh,
on
good.
the 5-year forecast and also did a DCF analysis, a discounted cash flow analysis, compared the numbers, and then saw the intersect between the DCF and just working off the projections by themselves.
Good. Yeah, that's an important point because we want to look at the valuation from a discounted cash flow perspective, not just a multiple times adjusted EBITDA, and see how those two converge and merge together. So I think that's really important. The other thing, Gary, in looking at the financials would be the cap table. We find a lot of times private companies do not have a very good cap table, especially if they have preferred shares, et cetera, and they somehow, for some reason, they don't maintain these very well.
Well,
So-
fortunately, whether by intent or otherwise, since the company was established so many years ago, and it was established by the two founders that are still the only shareholders, so
Okay.
they each own 50% each. There is no other class of stock. And with regard to employee ownership, they're in the process of talking with their attorney about the pros and cons between an ESOP versus a phantom stock plan. In other
Okay,
words, SAR, stock appreciation rights.
right.
And it provides the same incentive to the employees, whether it's actual ownership or phantom ownership, because they participate in the equity upside the same way.
Well,
But
the phantom ownership is a lot cleaner. An ESOP
that's
can
because,
be messy, and
yes,
oftentimes you have to get rid of the ESOP before you make the sale.
that
So-
plus the fact that with the ESOP in place,
Right, right.
you have the complication of getting approval from a minority shareholder to sell the company.
Yep.
That's not an issue with the phantom stock plan.
Exactly. You know, Eric, another thing in looking at not only just the industry, but this client has told us that they have a new valve coming out and they've applied for a patent. So we need to really look at the balance sheet because it probably doesn't include the intellectual property that they have, but that has some value here, right?
Yeah, and like you said, they don't typically include it. And one way to potentially, add to that is to potentially do a valuation on IP, right? To
Right.
To determine what that value is. Yeah.
No, that's
So-
very true. The other question I think, Rhett, that we really need to ask is, have the two owners told anybody else in the company about this sale? And who are those players? How would they be involved, et cetera, right? Because we need to know how far our contacts can go to maintain confidentiality during the sale process.
Definitely. At some point, you're going to have to let certain individuals within the organization know so that they can help you through the due diligence process.
Like the CFO controller probably is the most obvious one. Yeah.
Absolutely, yeah.
Yeah.
It typically is kept under wraps for as long as possible just to prevent the word from getting out there, which can disrupt the whole transaction.
Right.
So it's best to mitigate that as well as possible, but at some point it'll need to happen.
Got it. And Eric, we know in this case, because we've actually set that aside and we know this is factual, that the engineer, there are two owners, an engineer and a salesperson. The engineer wants out. So we need to ask the question, where's the continuity? Are the salesperson willing to stay? For how long, et cetera? So that's kind of a query that you would ask, right?
Yeah, I mean, I would also ask, the current owners, have they groomed anybody else,
Good.
in management and any of their other staff to replace that owner when he exits? There's that transition period that we're talking about here. Is there somebody to replace them especially if they've, been with the company a long time, they know where the proverbial bones are buried as to where they need improvement versus bringing in a new executive from the outside.
Yeah, we know buyers put a lot of value on key management people that are going to be retained by the company. So either under contract or, as Gary mentioned, maybe going forward under a phantom stock plan, et cetera.
One of the incentives that we might offer the remaining shareholder, the engineer in this case, is to suggest to him that maybe he roll over, say 10% of his equity. So he's still participating in the upside and he still gets a really, really big check at closing.
Got it. And Gary, while you're on that point, I think the other thing that we need to dive into at this stage is what type of employment agreements do they have? We talked a little bit about the fact they don't have necessarily an ESOP, but if they did, it would have to be wound down. But there could be all kinds of agreements in place that we're not aware of, that a phantom stock agreement or certain employment agreements. So,
well, currently, the management that does have the non-owner management that does have an employment agreement, of which there are several.
Okay.
It's not a particularly comprehensive employment agreement. It's more of the standard generic employment agreement that specifies base salary, maybe an annual kicker for cost of living and so on and so forth. Maybe some loose reference to an incentive bonus based on performance. And what we're proposing that the client discuss with their attorney is to modify those current employment agreements, make them more attractive, better defined, and include specific bonus provisions with regard to performance, but also a special formula for an added bonus upon the sale of the company, or at least a change of control. So even if it's not 100% sale, even with a 60, 70, 80% change of control, those management people would receive a special bonus upon the sale of the company based on a predefined formula. And we think that having that all together and then presenting it to management when you have that critical meeting with them will certainly capture their attention.
Right, and it'll lock them into place, and they're positive about going forward with the sale. I think we've covered a lot of things. One of the things that keeps coming up in these types of conversations is, Mr. Prospect, do you have any things that you've hidden? Do you have any potential product liability issues? Are you in lawsuits right now with any customers or vendors? And we really need the prospects to open up about that. We really need to know about those things, because the buyer's going to find out, right? And if we haven't identified these and provided a solution via our prospect, who becomes our client, buyers walk away if there's all kinds of things that they find out that were hidden, right? I mean, Aaron,
Yes.
Any comment?
Yeah,
Any thoughts?
yeah, I have a comment. Another important thing is staff, as far as their employment status, whether they're independent contractors or W-2s, and how are they operating and working within the business, and is there compliance? Because sometimes where businesses have employees overseas and they're contractors, and that becomes an issue with potential buyers.
Right. That's another issue.
I would like to add to that, Davis.
Go ahead.
That because the client has reviewed financials, and I guess, again, we're blessed with having reviewed financials versus just simply compiled. If I understand correctly from the CPAs that I'm acquainted with, is that with reviewed or audited financial statements, they're required by the professional standards to actually obtain a letter from the client's attorney or attorneys plural that asks them to identify any pending or ongoing litigation, any other threats that are of a contingent liability nature, And then, we would certainly be able to obtain a copy of that letter from the CPA firm, and plus the fact that they would disclose anything they found from the attorney's letter in the footnotes to the financial statements.
Got it. Okay. I think we've kind of covered the waterfront. There's probably more things that we would hone in on as we get responses from the prospect, but I think we've pretty much covered. Rhett, any last closing thought or comment?
I would say to address the net working capital at the beginning rather than the end.
Bingo. I love it. That is a really critical aspect. Yeah, because it's going to come up in the contract, and it supersedes or goes beyond the purchase agreement, right? It's that net working capital amount that can be
that
a
typically
dispute.
derails deals, especially if you don't address it until the end.
Great point. Thanks, Rhett. Thank you all. It's been enjoyable, and we'll talk soon.